Chandra Middleton. I'm the director of the Associates Program here at the Environmental Law Institute. That means I'm in charge of educational offerings like this and also membership. So if you'd like to learn more about what ELI does, both in terms of education and also in terms of research and policy, please visit our website at eli.org. So today we have Clean Water Practice, presented as part of our summer school series, which is made possible by our members and also with co-sponsorship from DC Bar's Environment, Energy, and Natural Resources section. So for today, we are joined by two excellent faculty who are joining us again after having done it last year. We have Alex Dunn and Erin Flannery. Alex serves as the Executive Director and General Counsel of the Association of Clean Water Administrators. She has 16 years of experience in environmental law and policy and has worked extensively on water quality, water treatment, and implementation of the Clean Water Act. She's also a published author, speaks regularly on water policy, sustainability, and environmental justice, and she sits on ELI's board, and we're very happy about that.
Yeah, thank you.
We also have Erin Flannery, who gained experience in fisheries and water law through internships at NOAA's Office of General Counsel, NRDC, and the Hudson River Keepers. She worked in EPA's Clean Water Act Section 404 Wetlands Program before switching to the NIFTY program. And I'd like to make a comment that her remarks in this course represent only her opinions and are not those of the position of EPA or the U.S. government. So with that, I will turn it over to Alex and Erin.
Thank you. So Alex and I really love giving this talk because we get to talk about the Clean Water Act, which we both work on and love. I will also mention that Alex was my professor at Pace University School of Law, and we enjoy doing this together. So one of my professors at Pace, my Clean Water Act professor at Pace, always started each class presentation and ended each class presentation with a picture of clean water. So I've started to do that too. This is Lake McDonough, Barkhamsted Reservoir in my hometown of New Hartford, Connecticut. And in addition to me using it for recreational purposes, as you see by my kayak, it's also the municipal water supply for the Hartford area. So it's also a drinking water source, and it's a water that supports multiple uses. And that's a theme that we'll continue to talk about through the rest of the presentation. And as Chandra said, I'm here in my personal capacity. I really enjoy teaching and talking about the Clean Water Act. I do work at EPA, but this is not an EPA-sponsored presentation. My opinions are not those of EPA.
Great. Well, and Erin and I, thanks for the intro. I enjoy doing this with Erin too. And we have folks in the room. How many of you are aspiring to go into environmental law or policy? Hands up higher. Come on, I'm a professor. Okay, good. And how many of you are currently in environmental law and policy as a practice or job? Okay, good. So we have a range. And how many of you would consider yourselves like fairly seasoned in the Clean Water Act? Okay, just one. So you're going to give us a hard time, and one like this. So good. So over the years, we've kind of refined. We've done this together a couple times, but what I really like about the presentation is it's evolved as both of our careers have evolved in different ways, and so it has some interesting, I think, angles, and it's not the same talk that we gave last year. If any of you were here last year, and I think that it's important to note that really you can't give the same clean water talk more than about within a month period, because it is constantly a changing field of law, including the Supreme Court granting cert last week on, oh, hello, another former PACE person, or current PACE person. The Supreme Court just granted cert last week on 2 water cases. So, I mean, literally, you have to just constantly stay on top of developments in this field. And that's a really exciting part of working in it. Another thing that I think keeps this area really dynamic is we're just really not there. The Clean Water Act sets some fairly ambitious goals, which we'll talk about, but to essentially, eliminate discharges of pollutants to U.S. waters and restore and maintain the biological, chemical, and physical integrity of the water. And while that seems like, it doesn't seem easy at all, frankly. I was going to say it seems like a reasonable task, but it was a pretty high bar. And this is the 40th anniversary of the Clean Water Act. It was enacted in 1972. We'll talk a little bit about that. But But today, we still have a lot of clean water challenges. They may not be as obvious as to the sort of naked eye that they were back in the days when the act was passed, but the challenges actually, the impairments, the sources of pollution have, and the ways to control them have gotten really much more complex. And were things that were maybe more easily addressed with a single tool or a handful of tools in the early days of the statute now are requiring a lot of creativity. So I'm going to turn it to Erin. Maybe we'll go back and forth and see how that goes.
Great. And let's see what the go back one. So when we talk about water pollution, what is it that we're talking about? Well, we are talking about things like CAFOs, concentrated animal feeding operations, factory farms, like you see the cows, and we have another picture of pigs later on. We're talking about point sources, defined discrete conveyances that through which pollutants are discharged into waters of the United States. You might think of a pipe. You can see some outflow pipes in those photos there. You also, a point source could be an excavator, where an excavator was discharging dredged or fill material into a water of the United States. We also deal with non-point source pollution, places where we don't know exactly where the pollution is coming from, but we know it's a problem. We know that there's an addition of nutrients or sediment into a water, but it's from a conglomeration of sources. We can't point to exactly which source it's coming from. So we have industrial point sources, stormwater, CAFOs, as I said, nutrients, publicly owned treatment works, a whole variety of sources that are contributing to our decreasing water quality. And it is important to Americans that we have clean water. Gallup did a survey, and people cared most about environmental issues related to water. 77% said that they were concerned with pollution of drinking water. 79% were worried about pollution of surface water, rivers, lakes, and reservoirs. So this remains a constantly changing area, as Alex said, and something that's really important to protecting human health.
Absolutely. So what we'll do over the next little bit, and we did say we'll kind of hold questions, I guess, to the end, but if something is just urgent, feel free to interrupt us. We'll give you a little bit of an overview of the statute's history, but we'll keep that pretty brief. Cover some of its substantive provisions, some of the procedural provisions, and then the hot topics. So maybe I'll tackle this first one. So I really like how Erin has approached this slide. It's evolved from earlier talks, which is, where do you look for clean water law, and where's the authority for clean water law? And the one thing, as we heard today when the Supreme Court came down with the healthcare decision, right? One of the things was the Commerce Clause, right? They held, for those of you who've read the late breaking news, the Commerce Clause was not sufficient authority for the universal mandate in healthcare, right? Well, the Commerce Clause is the authority for the Clean Water Act. So that's good news. That's been fairly long established. So the idea that water flows and has a relationship to interstate commerce, many things, we have economies built on water. And we're not just talking about, boats transversing, but waters themselves that cross boundaries, that whether underground, above ground. So there's really no question that, why do we have national federal law? You always have to have some sort of constitutional foundation for that. It's the Commerce Clause. And remember that because actually there are limitations to the Commerce Clause, as the Supreme Court held this morning, and we are still trying to figure out in the area of clean water. We talk about waters of the United States and their role in interstate commerce. Periodically, we do come back to that Commerce Clause authority, and it sort of tests the limits of the Clean Water Act. And when we say test the limits of the Clean Water Act, it's really important to remember the limits of federal law. And because I work with states now, I've learned a lot about the role of states in controlling clean water. And so if it's not federally covered, it might be state covered. And so you need to think about all these places. You've got federal law, federal regulations, and case law, but you also have state law, state regulations, and state case law. And many states in the U.S. Have provisions that they are not allowed to be more stringent than the federal government. But there are plenty of states, I'm sure you can think of some, that have no problem being way more stringent than the federal government on lots of things. So it's very important not to forget to check your state law.
Absolutely.
Okay.
So we're where did the Clean Water Act come from? We know now that we can find clean water law in a variety of places that Alex just mentioned. Before the Clean Water Act and before any environmental statute came into being, folks would often try to remedy harms to the quality of their water through common law routes of nuisance and trespass. But the results from those cases were inconsistent, and there was no nationally consistent way to address water pollution issues. In 1899, Congress promulgated the Rivers and Harbors Act and the Refuse Act. And the Rivers and Harbors Act gave and still gives the Army Corps of Engineers authority to, it's still administered by the Army Corps of Engineers. It made it a misdemeanor to discard refuse into navigable waters and their tributaries, to excavate or fill navigable waterways without a permit. It was really aimed at hindrances to navigation. That's hence the name Rivers and Harbors Act. But it also made it inherently wrong to pollute. It made it wrong to hinder navigation, interstate commerce. And there's, we can see a direct connection of how that came to the modern Clean Water Act. And except for the Rivers and Harbors Act, water pollution control developed originally as a state matter rather than a federal matter. And the 1948 Federal Water Pollution Control Act, or FWPCA, provided technical assistance and construction grants and partial funding to states for municipal sewer authorities. It gave authority to bring public nuisance suits to abate interstate water pollution when all other means failed. But states established their own treatment requirements and enforced them. But in the late 1950s, 1960s, there became increased public concern about water pollution. The upper picture there is a picture of the Cuyahoga River burning. This picture is from 1952. It burned several times from all the industrial waste that had been discharged into the river. Rivers burning is not something that's good for public health. The lower picture is a picture of the proposed project at Storm King Mountain on the Hudson River. And in 1962, the Scenic Hudson Preservation Council sought to stop Con Edison from building a hydroelectric dam, which you can see that it was going to be cut out of the mountain. It would have supplied electricity to New York City. But Scenic Hudson submitted evidence that power plants like this were destroying large numbers of fish and contributing to heat pollution in water. And the Second Circuit held then that the Scenic Hudson Preservation Council had standing to sue based on a harm to non-economic interests, to aesthetic interests. So in 1972, Congress passed the Clean Water Act. There have been several amendments, including in 1977 and 1987. And the goal of the Clean Water Act is to restore and maintain the chemical, physical, and biological integrity of our nation's waters. And it is administered by US EPA's Office of Water in partnership with the states. So there's definitely a cooperative federalism approach to the Clean Water Act's administration. And as we'll see in a few minutes, the Army Corps of Engineers also has some authority under the Clean Water Act.
Okay, so, all right. So the heart of the act I referenced before, I guess, almost from memory, but, you know, an ambitious goal to restore water quality and also to eliminate the discharge of pollutants, and I think that's a note there, without permits, okay? So I always like to say that the very statute that said we were going to eliminate discharge of pollutants actually created a permitting program to continue allowing pollutants to be discharged. But it was about controlling those discharges, so you didn't have unknown things going into the water. It was about thinking about the levels at which we could tolerate pollution, essentially continuing to go into our waters. You know, I work often with a lot of NGOs who'll say, you know, the National Pollutant Discharge Elimination System, NPDES, which you'll hear us talk about later, which is the permitting program, you know, elimination system, what happened to elimination? Once again, I think there was a recognition even by Congress when they passed this law that they weren't going to really eliminate it, but they were going to try and control what was going into the nation's waters. So how is that happening? It is happening through water quality standards establishment. It's a fairly technical area. For those of you who like biology and science, you should enjoy water quality standards. But basically, every state was challenged by a short deadline to identify the purposes and uses of waters within their boundaries. That sounds also quite ambitious, because we're not just talking about the whole Cuyahoga River. We're actually talking about segments of rivers. And so even lakes, streams, every state was asked to categorize all the waters and list them, whether they were for industrial use, drinking water supply, okay? You're gonna have a different need if a water is going to be used for drinking water. Drinking water is treated, okay? So it doesn't have to be pristine enough to just put a glass in the water and drink it, although you might do that when you're kayaking, I don't know. That water gets treated too, yeah.
Want it to be treated
Yeah.
first.
But basically, is it recreational fishing? Is it primary contact recreation? Are people there swimming? Is it a swimming beach? Because we're going to have different standards for bacteria if people are actually there swimming. We're going to have different standards in temperature, as Erin alluded to. If there are cold water fishery, they need a certain temperature. So water quality standards is all of that whole field of identifying and categorizing waters, and then through the permitting program and other tools, achieving those goals. Listing impaired and threatened waters. Impaired means literally impaired for a variety of pollutants, so the water could be too warm for that standard. It could be too cold for the standard. It could have too high levels of bacteria or nutrients to achieve its goal. Threatened waters is a really interesting area that we didn't spend a whole lot of time on in the first 3 decades of the law, but now I see a lot of effort on protection of waters. You saw those burning rivers. So the early decades of the Clean Water Act were about, trying to control, these obvious sources of pollution. And we spent so much time dealing with impaired waters that now we're actually realizing, wait a second, states also were asked to identify their high quality waters that were in great shape. Maybe places that you don't want them to get worse. You want them to be better. Did I touch that?
I have no idea.
Okay.
Let's try that one again.
All right. Well, does that mean we lost our people on the phone? Mm-hmm. Okay, so maybe I'll just pause for a minute while we're redialing. Does anyone in the room have any questions that will now be officially off the record? Or maybe not. You guys are hanging in there? We both talk pretty fast, so we'll get those guys back.
Harder to dial for them.
Yeah, I'll just do it real quick. I'll get to special purpose
Okay.
internet.
Okay, that sounds great.
Hello, to those of you still on the phone. Sorry about that. We're back and you haven't missed anything.
All right, so still working, folks on the phone have the PowerPoint?
Yeah.
Okay, great. So we're still at the slide called Heart of the Clean Water Act. Okay, so breezing through this, monitoring and management. Monitoring is also at the heart of the Clean Water Act because we really can't make improvement without monitoring, without knowing what's going on in that water body. So again, an entire field of water quality monitoring. USGS plays a big role in monitoring nationally. It's a dynamic area. TMDLs, another acronym, lots of acronyms in this law, but a TMDL is a total maximum daily load. So for a water body that is impaired for, say, phosphorus, the state would go in cooperation with EPA and develop a total loading that water body can handle before it sort of takes a turn for the worse, and then cap that loading and then allocate that load of that pollutant to all the entities working in that water body. It's also a very powerful tool, also to slowly bring down levels of pollution. If a water body is impaired, there can be no new increases of that pollutant. So that can be a big deal. If a water body is impaired, say for sediment, you saw those bulldozers on the prior slide, and a developer wants to come in and put in a new subdivision, they're not going to be able to add any more sediment to that water, and it's pretty hard to build a subdivision without stirring up some soil. So TMDLs can also have a major effect on the economy and growth, and so for that reason, they're also very powerful tools. Permits to point sources, which we'll talk about later, and then voluntary programs for our non-point sources. So we'll get you set on point, non-point in just a little bit. I'm going to go very quickly through these, frankly, because they're not all that interesting. But just to let you know that, like any law, there was some early tweaking and fixing to try and get it right. Between 72 and 77, there was some frustration that things weren't moving fast enough. Okay, there was a great pent-up desire for improvement. And so this is where the statute actually got its popular name, and we added a focus on toxics and changed some deadlines. In 1981, the statute was amended again to go from grants to communities to upgrade their sewer systems to creating a loan program. Very, very important. Actually, no, the program was overhauled here. I think that the grants to loans switched in 87, which I'll turn to here. Yeah, we went from grants to loans. So again, in the beginning, you might often hear that that President Nixon vetoed the Clean Water Act, and it was passed over presidential veto. That is true. Part of why he vetoed it is because it was a very expensive law when it was passed. It was grants. It was money. Money was flowing to these communities. We have such a water quality problem in this nation that we are going to give communities federal money to invest in their sewer systems. Well, by 1987, everyone was saying, this is unbelievable. We've got to make these loans. We can't just give money away. So again, reform, reform, reform. And in 87, a very important thing was realized. We've been making progress with our point sources, but not with our diffuse sources of pollution. So new programs were added in 87 that are very relevant today, the stormwater program. And then the final slide that I'll touch on here is what you see today. The law is still being amended. There'll be little tweaks here and there. And if you notice these, the theme really is a lot of focused amendments. So again, reflecting the maturity of the law, that we're now looking at the Long Island Sound, the Chesapeake Bay, our understanding of big watersheds and their value really also matured as the law moved along. And so many tweaks to the law to really focus on, say, beaches or special watersheds, Great Lakes. And this is just through the 2000. There have been many, many more amendments that are very focused on little issues. And with that, I'm going to turn it to Erin to get you to the core of the statute.
Yes, Alex and I like to think about the core of the Clean Water Act in terms of 3 Ps: prohibition, permits, and penalties. As an innovative national law, the Clean Water Act adopted a strategy requiring discharges to reduce pollution in their effluents as much as possible via different control technologies. Before, the strategy had been based on reducing pollution based on water quality only, and the Clean Water Act does both. And it also created a sophisticated and streamlined system for regulation and for enforcement with significant penalties for noncompliance. And the Clean Water Act, through its citizen suit provision, also empowered citizens to participate in the implementation and enforcement of the act itself. So again, we're breaking this down into the system of 3 Ps: prohibition, permits, and penalties. And the first P is the basic prohibition. So basically, we're saying if you're discharging pollutants into waters of the U.S. and you're not in compliance with water quality-based effluent limitations, technology-based effluent limitations, limitations for toxics, special limitations for aquaculture, or the National Pollutant Discharge Elimination System permitting program, or the dredge and fill permitting program, your discharge is prohibited. Any unauthorized or unpermitted discharge of a pollutant by a person is unlawful.
You want to take the next one?
Sure.
Yeah.
So in law school, we think about statutes as far as their elements. What do we need for a basic Clean Water Act violation? Well, first we need a discharge, the act, of a pollutant, and we'll get to that definition, by any person from a point source or of dredged or fill material into a water of the United States, except as in compliance with the listed permitting programs, for example, 402 and 404. You might think, is a mental state required? Because it's not listed there. And the Clean Water Act is a strict liability statute. For civil penalties, penalties can attach even if you don't know you're violating the act. And you can be subject to administrative or civil sanctions. The Clean Water Act also has criminal liability provisions with mens reas of negligently, knowingly, recklessly, or purposely, and then criminal sanctions might apply, including jail time. So, for example, if you are the owner of a corporation and you know that every month you're violating your discharges, the discharge limitations within your permit, and you continue to do it, maybe you even encourage your employees to do it, or you know that you're doing it and you just don't care, criminal liability could attach.
Okay, so discharge is a defined term, and it seems pretty simple, right? Any addition of a pollutant or combination of pollutants to waters of the United States from any point source. But believe it or not, every word in there except the connectors, like any or of or the, is loaded with meaning. There has been recent litigation on what it means to add. What is a pollutant has also been litigated, or combination. Waters of the United States, we're going to show you, is still not really known. And what is a point source is also still being expanded and added to.
So it's, again, like we said, very exciting act to be working with.
Yeah, really. There's just, and I think that's a reflection of the fact that people really do want clean water, and there's just a lot of pressure to make things better. So maybe I'll take the defined term of what is a pollutant. And one thing that, I will not read this to you, but one thing you should look at when you look at that list is that we are talking about, you'll see chemical waste, but you also see things that are natural, like rock and sand, and even heat, okay? We've mentioned now a couple times temperature. You wouldn't really think of temperature as like a pollutant, but in the ecosystem, it certainly can be. If any of us go outside later today when it might hit a record, we can definitely say that heat can alter species feelings in the environment. So, so the Congress was really, I think, quite ambitious and intelligent in writing this definition. Well, it's in the statute, but it's also in the regs. A very, very broad concept. And so some of the recent litigation over what is a pollutant is whether it's actually a waste. So when does something become a waste? There's been some litigation on that. There's been litigation on whether fish parts that get chopped up through some sort of industrial process would be pollutant, and yes, they are. You can probably think of other things that have been found to be pollutants.
Well, again, like thinking about things like rock, sand, dirt, even if they're naturally occurring in an ecosystem, the addition of more of them via a construction process, or the addition of dredged or fill material into a water that does not naturally have those items in there, would be the addition of a pollutant as well.
I'll let you take these next ones. And
Okay.
just on addition, I will say, we don't go into that one, but the recent litigation that's gone all the way to the Supreme Court and back on addition is moving water from one place to another. So just merely transferring water. So if this is water body A and this is water body B, and I have a tunnel, and I merely move the water from here to here and do nothing else, have I added water? What do you guys think? Is that an addition of a pollutant? Is water itself, untreated water, a pollutant? It could be, right? It could be, because water is chemistry, and what's in that water, it could be very different. So that's how subtle the litigation has been in this area.
Oh, yes.
I don't want to interrupt, but just one curious thought from the right. What about invasive species and non-native species?
They are.
They could be,
They are biological
materials.
So the question for those on the phone was, what about invasive species? Could they be pollutants? And actually, in Aaron's part of the EPA, there are new regulations for vessel and ballast water discharges, and part of that is because the vessels come in with water that they've picked up, and there's species that they've picked up in that water, and you have to be very careful how it's managed.
All right, so our next element is that a person has to do this, either an individual, a governmental entity, one of their agents, a corporation can be found liable for violating the Clean Water Act.
state or federal.
Yep.
So government, the government itself is subject to all these laws.
So point sources are discernible, discrete, confined conveyances, including the things that you might ordinarily think about as something that would discharge pollutants, pipes, ditches, channels, tunnels, CAFOs. Alex just mentioned vessels. But the regulations also exclude certain things from being point sources, including agricultural stormwater, irrigation return flows, and non-point sources. We talked a little bit about diffuse sources where you're not quite sure where it came from. So those aren't point sources. And a person, even though a person has to discharge from a point source, a person is not a point source himself or herself.
Which is good news for all of us, or we'd all be permanent dischargers.
Here are some more visual representations of point sources.
Right, and this slide actually gives you a sense. We've got aquaculture in the picture. We have an overflowing manhole we have the aerial spraying of pesticides. We have shipping and vessel water. We have consolidated animal feeding, and then we have down a forest road, which the U.S. Supreme Court just granted cert last week on the very issue of a forest or logging road and how that might be covered. So again, a very evolving area of the law, and the exclusions are quite significant and again reflect, I think, where Congress's focus was when the act was passed was on industrial type activities. But now today we're looking at forest roads. They are an industrial type activity, but for a long time they were considered to be the diffuse source. There's no pipe there. There's no really thing that you could point to, although a road channels water, right? So we're really now trying to capture as many sources of pollution as we can. You want to take the next one?
Sure. So the Clean Water Act itself defines navigable waters as waters of the United States. And then the regulations, which EPA and the Army Corps have identical regulations of the definition of water, where it defines waters of the United States, includes the following things currently. All waters used or susceptible to use or used in the past for interstate or foreign commerce, including tidal waters. Interstate waters, waters that either form a border or share a border between states. All other waters that could affect interstate or foreign commerce. Impoundments of waters in the United States, just because you impound a lake or stream doesn't take it out of Clean Water Act jurisdiction necessarily. Tributaries of the waters that are listed above them. The territorial sea, 12 miles from a state's shore, and wetlands adjacent to the waters identified above. So this area, as we're going to talk about for a couple more times during this presentation, is heavily litigated, and there are a lot of people thinking about this very topic right now. So the Army Corps of Engineers has available for the public this diagram describing where one might find waters in the United States. Remember I mentioned the Rivers and Harbors Act before, Section 10, which was concerned with keeping debris from impeding navigation in traditionally navigable waters so that it wouldn't interfere with interstate commerce. So right there in the middle you see a navigable water with an ordinary high water mark, jurisdictional under Section 10. Also jurisdictional under Section 404, but Section 404 goes a little bit beyond that, and it includes wetlands and waters adjacent to the traditionally navigable waters. But there's not Clean Water Act jurisdiction in uplands, water areas of land that are completely separate from waters. And the regulatory definition has been interpreted to cover a lot of different kinds of surface waters: rivers and streams, lakes, ponds, wetlands, sloughs, prairie potholes, intermittent streams, and the territorial sea. Here's a photo of a wetland complex and stream just outside Portland, Oregon. And there's you can see the stream going through it, and then there are wetlands right up against the stream. Those are adjacent wetlands, so jurisdictional under the Clean Water Act. Clean Water Act also has regulatory exclusions for what is not a water of the United States. And these include waste treatment systems and prior converted cropland. Waste treatment systems might be ponds or lagoons where treatment is occurring or settling. And within this confined area, dischargers into the waste treatment system don't have to meet water quality standards. discharges that come out of a waste treatment system do need to be permitted under Section 402 and meet water quality standards. And prior converted cropland are areas, wetlands that have been drained, dredged, filled, leveled, manipulated before a date in the Farm Bill from December 23rd, 1985, and that they have not since been abandoned. So we talked about how the idea of waters of the United States has been litigated recently, and the next slide talks about two major Supreme Court decisions.
You want me to take those?
Sure.
Okay, so one little theme you may be picking up on is some favorable treatment for agricultural operations that continues to crop up, and the role of the Farm Bill and the exemptions for things like agricultural stormwater and non-point sources, and that remains at the heart of a lot of our fights about what's covered. So a couple of major decisions that really we could teach a whole class on. But I'll just mention very quickly. So on that picture of what's included, remember at the beginning we told you the Commerce Clause, right? Interstate commerce is the authority over the Clean Water Act. So in the Swank case, where I keep skipping it. There we go. The Solid Waste Authority of Northern Cook County in Illinois is the acronym for SWANK. And very interesting little fact pattern here, but Chicago knew they were going to have more trash, right? More people live in Chicago, they're going to have more trash over time. And so the short form of this is the Solid Waste Authority of Northern Cook County purchased an area of land that had been used for mining and gravel pits, with the intent that later it would become a future landfill for the county as it grew. They didn't need it right away, though. And so what happens to abandoned mining areas, abandoned in the sense that they're not being actively mined, is they fill up with water. And so over time, this is filled up with water, and grasses had grown. And the Solid Waste Authority then said, well, it's time for us to drain this area, and we need to start using it for our landfill. And the question became, well, wait a second, we have this beautiful water here. We have a water of the United States, and if you are going to drain it, you're going to have to get a permit. And so the fight became, is this a water of the United States? The U.S. Supreme Court held no. Now, we have a mining area in Illinois that you saw the prior slide. They couldn't show that the water was connected to a traditionally navigable water, okay? It wasn't like close to a river. It wasn't connected by a bunch of soggy wetlands that got you to a river. It was really just in the suburbs of Chicago. And so the authority that the Corps used was a migratory bird theory, okay? So we have to connect this isolated gravel pond in the suburbs of Chicago to interstate commerce. And they tried really hard to do that by saying that there were birds. Birds were flying from other states into Illinois, and not only were birds moving there, but then birders were coming to watch the birds, and they were crossing state lines, and there was this economy. And we have friends and former colleagues who are big birders, and there is an economy in birds, but and bird watching, but the Supreme Court said no. Now you've gone too far. Okay, there is a limit to the Commerce Clause, just like they said this morning. You can only just stretch this so far, and migratory birds and people looking at birds to get jurisdiction over water, no, not going to happen. So just remember that, what does that mean? It's not covered by the U.S. Clean Water Act, the Federal Clean Water Act. It would be covered by Illinois state law. So that we know that fully isolated waters, not jurisdictional. Fast forward now, okay, so fully isolated are out, and ones that are proximate are in. The Rapanos case was the latest, which tried to figure out, okay, so how do we draw these connections? And in this case, this was our 4-4-1, the plurality. It's a crazy Supreme Court split. It was 4-4-1. Lawyers that have been practicing for a long time had not seen one of these, and it's basically you go with the rationale that most of the justices followed. And so the rationale became Justice Kennedy's assertion that, okay, so somewhere between wholly isolated and proximate is a concept called a significant nexus. So it'll be jurisdictional if we can show a significant nexus between that water and the traditionally navigable water. This is a really complicated area. I said we could teach a whole class about it. But let's just say don't assume your water is jurisdictional when you start working in this area. But a lot of waters surely are, because hydrogeology connects a lot of waters. They can be connected underground, above ground, and that was really the issue that we still struggle with today, is showing that significant nexus.
Right. So Justice Kennedy wrote his significant nexus opinion, and Justice Scalia wrote of the plurality opinion saying that relatively permanent or seasonal waters or wetlands with a continuous surface connection to those waters would be jurisdictional. Only the 11th Circuit has said that you must find jurisdiction via a significant nexus Kennedy test. Other circuits haven't said which test you must use, and in their briefs the government has argued either way. And so now it is up to the Army Corps of Engineers in their Army Corps of Engineer districts to make jurisdictional determinations to determine whether or not a water is a water of the U.S. in consultation with EPA regions.
Right. So it's a very complicated area of the law, a very interesting area of the law, and one that continues to be litigated. So let's assume that you've determined that the water is jurisdictional.
Now
okay? You need a
permit.
Yes.
Another P. So a violation of the Clean Water Act, as we said before, would involve a discharge without or in violation of a permit. And a permit is an authorization or license issued by the government to do something you ordinarily wouldn't get to do without the permit. And the permit can also be revoked for cause. There are two main kinds of permits in the Clean Water Act. Under Section 402, we have the National Pollutant Discharge Elimination System permits, or NPDES, or NPDES. These are issued by EPA or an authorized state government, and currently 46 states are authorized to issue those permits. And in Section 404, the Army Corps of Engineers or an authorized state government, currently there are 2 state governments authorized to administer 404, issue permits for the addition of dredged or fill material into waters of the United States.
Maybe in the interest of time, we'll kind of skip these next couple slides,
Okay.
which are some details about the 404 program, which is run primarily by the Army Corps, the 402 program, which, as Erin said, is run primarily by EPA and the states. And there's the state map of which states have authority over this program. The state of Alaska is the most recent state to assume authority. Most of the states assumed authority fairly early on in the early days of the program. Alaska and Arizona in the past, Alaska just in the past year, Arizona a few years before that are the last 2 that have taken the program. And those handful of states that have not taken the program, which are in dark blue, are in no rush to take it.
So the EPA regions in those where those states are located, Idaho, New Mexico, Massachusetts, and New Hampshire, the EPA region issues the permits instead of the actual state.
Yeah. All right. So another P.
Penalties.
Yes.
One might be assessed administrative penalties or civil penalties under the Clean Water Act, and the amounts of those penalties were adjusted for inflation. And so currently, you could face a maximum penalty for a maximum civil penalty under the Clean Water Act for $37,500 per day per violation.
So we won't spend a long time on penalties. We'll turn to our other mnemonic to remember and teach the statute. We had our 3 Ps, and now we have our 4 Rs. So if you did have a permit, and here again, we're talking about the NPDES permits. These are the 402 permits. These are not the 404 wetland, dredge, and fill permits. So I don't think we're going to talk much in detail about the 404 permits. Because again, the 402 permits are the ones issued by EPA. And by the states. So a permit's going to have a number of things that you would think it would have: restrictions, reporting requirements, reopening, and as mentioned before, it can be taken away. A permit is not a property interest, it's not a right, it's a privilege. So, you want me to take 1 or 2? So again, when most environmental laws were passed, they were sort of technology based. Okay, it was what gadget or gizmo can you put on your point source? Because remember, we're talking about point sources, so we're thinking industrial activity. What can you stick on the end of that pipe or in the treatment process to control it? And EPA develops things called effluent guidelines, and the effluent guidelines are by industrial category. Effluent is what comes out of the pipe. A guideline is a guideline. It's really the best technology that could be used in a particular industry that's also affordable and economically feasible. So EPA puts a lot of time, energy, and effort into developing these effluent guidelines. If you look in the federal regulations, you will see one after the other for all sorts of activities. I worked on the meat processing effluent guideline. That was highly unpleasant one to work on. But there are also effluent guidelines for everything from
Battery manufacturing, ore mining and dressing for the mining sector.
And EPA is working on 2 new ones that reflect sort of the current challenges. One of them is shale gas extraction that might make some of you think of hydrofracking activities, and also coal bed methane extraction. So again, effluent guidelines move forward as technologies and industries move forward. And so there's always new ones to be developed to go along with the advance of technology and the advance of industry in our country. So a permit will first have some sort of limitation that is derived from the industry or activity that is at issue. Then there'll be a second type of limitation. You want to take
Sure.
this one?
So if a discharger is discharging into a water in the United States, that particular water will have water quality standards, which are meant to protect the quality of the water. So a permit writer will assess whether or not the technology-based standards are protective enough to protect the water quality standards of that water. And if they're not, then the permit writer will also include water quality-based effluent limitations within the permit. And so those are often more stringent than the technology-based effluent limitations. They're designed particularly for that water body. There are criteria within water quality standards to protect the particular uses for that water body. Alex mentioned before, primary contact recreation. Are people swimming in this water? Do we need to make sure that the effluent of the, say it's a factory, the effluent of the factory is not going to make that water unusable for swimming or as a drinking water source. And there's also, water quality standards also have an anti-degradation policy to maintain a high quality of water. And just briefly, if you are a permittee and you do not believe that you will immediately be able to meet the water quality-based effluent limitations in your permit, the federal regulations do provide for, when appropriate, a permit may specify a schedule of compliance leading to compliance with the Clean Water Act and regulations. You need to have milestones showing that you are making progress towards meeting your water quality standards, and you have to comply with water quality standards as soon as possible. You don't have an indefinite amount of time to come into compliance. You might need time to install particular control technologies, implement modifications to your plant. You might need to do an engineering analysis on your operations. But you must show those milestones leading up to your compliance with the water quality standards.
Right, and again, reflecting sort of the desire for the public to have really clean and healthy water, these compliance schedules have become more and more important because the limitations have become more and more stringent. A great example is Oregon just released the nation's most stringent, or created the most stringent water quality standards in the nation for fish tissue toxicity. Now, what does that mean? That means that people are fishing, people are eating those fish, and in Oregon we have a lot of tribes who are subsistence fishing communities, which means that they eat more fish than a non-tribal person might eat. And the limitation to protect that population is so strict that almost the day that the new standard was issued, the state simultaneously had to issue a an exception to all dischargers in the state because no one could actually meet it that day. And no one would probably be able to meet it anytime soon. So that's where you see sort of policy conflicting with a fairly rigid system, which is you're discharging, you have a permit, you have to meet this limit, and yet we have this policy goal of protecting people who are subsistence fishing, and we can't protect them, you know, at the rate that they're eating today, tomorrow, and probably in the next 5 years, which is the duration of a permit. So a lot of really interesting, I think, public health questions.
And environmental justice.
Environmental justice and
Implications
fairness issues come up in something as technical as permitting.
Yeah.
And then I think of this as a third kind of limitation because it's a good way to think about the TMDL program. The TMDL, remember I told you, is the pie, and it divides up the pie. And if you are a point source discharger in the pie, you're going to get your slice of the pie, and your permit will reflect your amount that you have, and you have to comply with that. So the TMDL itself sits over here, but your state will be looking at that TMDL for that water body and putting that limitation into your permit. So again, I think it's helpful to think technology first, anything else we need to achieve the water quality goals, and then third, there might be a TMDL at play that's going to derive another limitation in that permit.
So here's another R, reporting requirements. In an NPDES permit, there are requirements that the permittee report back to the permitting authority on some of the following things. They need to note in discharge monitoring reports how the discharge is doing. Have they exceeded the limits in their permits at any time? Have there been changes in the discharges? When one applies for an NPDES permit, one has a good idea of what sorts of pollutants are going to be discharged via the particular industrial process that you're operating. Have any of those pollutants changed that weren't in the application? Were there any upsets or bypasses that discharged a higher quantity of pollutants than was allowed for in one's permit? The permit also has a duty, the permit holder has a duty to provide information to the permitting authority and also grant the permitting authority right of entry to come and inspect. And depending on the source, the facility, there might need to be additional monitoring or special studies done. Maybe the discharger is a power plant in an area where, maybe in an estuarine system, where there's a spawning area for fish. And maybe the permitting authority thinks that it's acceptable to grant this permit, it's okay for the discharger to discharge pursuant to the permit, but they might need some extra monitoring or studies done to make sure that the populations of those fish are not being unduly harmed by the pollutant or the discharger.
Mm-hmm. And again, just remember that permits are not frequently viewed as kind of dynamic documents, but they could be if we had enough resources to really make them that way. So I say this in a practical sense that yes, a permit can be reopened by the issuer, the state, or in those states, the EPA, if there's a change. I used to work with chemical companies, and a chemical company, many of them are called batch manufacturers. So in April, they're making a paint additive. But in July, they've been commissioned by a client to make some new thing. And so that would be a case where their discharge might dramatically change. Now, if they have good lawyers, they'll contemplate all those things, and their permit will be broad enough initially to cover those types of variations in manufacturing. But if they're not, if they have a dramatic change, you would want to reopen the permit to reflect any new toxic standard, any new discharge. And then just briefly, our final R, revocable, as we said before. The permit can be taken away from you. It's not a property interest. It's not something that you own. And certainly there have been cases of false or misleading information being provided or continued violations. The permit can certainly be revoked and taken away. I'll let Erin mention citizen suits, a very, very powerful tool, because every one of you in this room today, if you're not a lawyer, could go home and file a citizen suit. You could file a lawsuit. You could become a citizen attorney general. Isn't that exciting?
One of the things that the Clean Water Act did that I mentioned before was increase the availability of public participation in this process. So there are the regulations provide for a lot of opportunities for public participation within the permitting process itself. But say you are an environmental organization or a citizen or small group of citizens who notices that a particular facility in your community is routinely violating their permit. Permitting permitting authorities have only so many resources to go after violators, so they can't see everything. And so Clean Water Act Section 505 provides for citizens opportunity to act like private attorney generals and bring a suit against the polluter. They file a 60-day notice of intent to sue. And if the state or the permitting authority is diligently prosecuting that case already, then you're barred from bringing a citizen suit.
And we could have a whole nother session on diligent prosecution, but I will say that the bar for diligence is quite low. And that 60-day notice, so you're, citizens for, the healthy river, and you file your intent to sue. Let's just say that in those 2 months, frequently either EPA or the state says, oops, we better do something. And the prosecution could be as much as the permitting authority writing to the facility and saying, we're very concerned about your discharges, bringing you in for a meeting, putting you under an administrative order, doing something to sort of bump that citizen suit from going forward. Needless to say, bureaucracies being what they are, sometimes they're successful in getting something in place that would be viewed as, sufficient prosecution, but plenty of citizen suits go forward. All right. And we're just going to close out with money again, because I did bring, and I'll leave it up here at the front, the Clean Water Act started being about money because, frankly, you can't clean up water without resources and money. This is a budget chart to show you all what's been going on, and we'll just make sure you get it before you leave. And I wrote in, because the House just this week has been slicing EPA's budget, including the state programs that are funded by EPA. Water funding is going down, and I just spoke with one senior EPA person who came over from the Superfund program, where they're doing a lot of cleanups, and she's been in the water program again after a decade of being away. And I asked, what do you notice the biggest difference after being in Superfund and coming back to water? And she said, I'm reminded of how little resources there are in the water program, because in the Superfund program you have large corporations doing the cleanups, and you have what are called deep pockets. In the water program, you really don't. The federal funding is going down, and it's going to hurt the water program over time. But there are still programs that are funded through the Clean Water Act, and the 3 primary ones that you need to know about are listed here. And now let's talk about some hot topics, right? The fun part. How much time do we have, Chandra?
We have about 45 minutes.
Are you kidding? Wow. All right, guys, get ready. Buckle your seatbelts. We could keep going. So we do want to talk about hot topics. Maybe we'll pause and just say, based on our overview and the rapid fire summary of the law, does anyone have any questions that will help you maybe understand the current issues more? Yeah.
Is there any requirement in the pollution definition that it be an adverse pollutant? Or can it be some, like, anything that's discharged, or does it have to be having bad effect on water?
So the question is, does the pollutant being discharged have to be having a bad effect or an adverse effect in the water? That's a great question. I would say there's no requirement, but most cases tend to be about the adverse effect of the pollutant.
Right. I would agree with that. I think some state laws might have that requirement of harm, but remember that it's a strict liability statute, so the addition of the pollutant by a point source,
It's
by
there.
a person is there. So, but oftentimes the people pay attention to it because there has been some sort of harm.
That's a good question. There was another one? Yes. Yep, that's a great question. So the question is, the technology-based standards and effluent guidelines, they are supposed to be the best technologies that are economically affordable by the industry. That is in the law. And so there is an economic assumption that goes into their development. But I think you're raising even a more sophisticated question, which is in the implementation, is there something that the company could do to show that they can't afford that technology? And once the technology is set, that is the technology that's generally applied. But one of our current issues right now is cooling water intake structures that suck lots of water in to keep a nuclear reactor, say, cool. That's important. But there are a lot of questions about what is the best technology for keeping those power plants cool. And a lot of arguments are being made about how affordable the technology will be. So in the process of developing the effluent guideline, economics becomes, almost the heart and soul of the argument.
Mm-hmm. And in other kinds of regulations that aren't effluent limitations, EPA will go through another kind of economic analysis to see the costs and benefits of the impact of the regulation.
Yeah, just a good takeaway, always look to see if cost is either listed in the statute or regulations as a consideration. Because we can't go into it in great detail today, but some provisions, cost is explicitly not included. And there have been cases about whether it be implicitly considered, but cost and the environment are two competing and sometimes conflicting goals.
I think I saw some more hands. Yes? We absolutely can do that. One of the case studies, one of the hot topics that that we're going to talk about does concern the Clean Water Act 404C authority, which EPA has to veto a permit that is issued by the Corps. When the Corps is conducting jurisdictional determinations to figure out whether a permit's even needed, there is consultation between the Corps districts and the EPA regions to make that decision. And the veto authority is particularly interesting. So if we could hold that till we get to that discussion, that would be great. And then we can talk more about EPA and 404.
Yeah. I can think of a lot. So revoking a state program is, there are petitions to take programs away from states. There are lots of petitions to take programs away from states from dissatisfied entities, but that is generally not the path we want.
It's never been done either.
Yeah.
EPA has never revoked authority for an NPDES program.
Right, so the kinds of things in practicality that happen, you can find resource support initiatives. So the EPA could provide money and actual staffing, loaning personnel from an EPA region to a state to help the state with particular issues. Also, the states and their EPA regions have every year go through a work planning process where the state and the region will decide who's doing what are the priorities for the year. So if there's an area where the state has been behind or maybe needs to do a better job, that usually would make its way into the work plan. It's like any kind of, frankly, business relationship. It's not going to be overnight that you'll see change, but you will see a desire to see improvement reflected in those kinds of things. Yeah. All right. Well, we should probably get to the hot topics.
Okay.
So, and we may have actually kind of covered our first one inadvertently. So that's what I get for, not reviewing my slides right before I got here.
We did go over
We covered
most of it.
this. We covered this. So
just to mention that, so as you may have picked up, figuring out Clean Water Act jurisdiction, what is a water of the United States, continues to be litigated and complicated. So in May 2011, EPA and the Corps proposed a Clean Water Act jurisdiction guidance to offer a new look at how one would determine Clean Water Act jurisdiction. So the guidance talks about that under this guidance, the following things would be jurisdictional: traditionally navigable waters, interstate waters, just like before, wetlands adjacent to traditionally navigable waters or interstate waters, non-navigable tributaries to traditionally navigable waters that are relatively permanent, and wetlands that directly abut permanent waters. And we talked about how Justice Kennedy proposed in his opinion, said that some waters could be subject to a significant nexus analysis. So the 2011 proposed Clean Water Act jurisdiction guidance suggests that the following things would be subject to the significant nexus analysis. Tributaries to traditionally navigable waters or interstate waters. Wetlands adjacent to jurisdictional tributaries or traditionally navigable waters or interstate waters. And waters that fall under the other waters category of the regulations. In the regulations, the third thing on that list is other waters that have a connection to interstate commerce. So these could include physically proximate other waters, maybe prairie potholes or vernal pools, things that don't have, that are close to jurisdictional waters. And maybe even the waters would be subject to significant nexus analysis if they weren't that close, if they were non-proximate to traditionally navigable waters. Sometimes prairie potholes are quite far away from traditionally navigable waters, but they support an abundance of wildlife and are important ecosystems. So again, with the significant nexus analysis, one would look for the chemical, physical, or biological connection, a hydrological connection to a traditionally navigable water. And the following things under the guidance would not be jurisdictional. Wet areas that aren't tributaries, they're not open waters, they're not wetlands. Waters that are already excluded by regulation, you might recall that I mentioned that waste treatment systems and prior converted cropland, not jurisdictional. Waters that have no significant nexus after that analysis has been complete. Artificial lakes, pools, ponds, ornamental waters, and erosional features that aren't wetlands or waters, or gullies, things like that.
And I'll just give my commentary here to say the fact that we have to clarify that an ornamental water is not a water of the U.S. or a pool, as in like a swimming pool, is not a water of the U.S. only shows you how how this debate has gotten just to the highest level of almost absurdity, because everyone's looking for this limitation. And if EPA and the Corps have to come out and say, yes, an ornamental water is not covered. I mean, people have said this glass of water, could be found to be a water of the U.S. There's a lot of, what do you want to say, sort of politics about this issue. And why does it matter, right? Why does it matter? It really comes back to a lot of another tension in environmental law and regulation, which is sort of private property rights.
Absolutely.
People wanting to do whatever they want on their land. Okay, that's like a core American value for some people. And it's the Clean Water Act is not immune from these kinds of pressures, and nor is EPA or the states. Another thing to recognize is you heard vernal pools, or ecosystems are really, really complicated, and water is not always present. Okay, so especially with climate change, there are areas that maybe are wet today that were not wet 5 or 6 years ago. There are areas that have dried up because of climatic changes, and yet you may still see sort of a gully there. Like there was evidence of water being there, and water may come back. Well, someone may say, I don't see any water, but there might be water there next year. And once you change that landscape, once you plow it through and put up your shopping center, it's gone. So this is really why there's so much fight about this. The other thing that's reflected in this fight is something that I think is really important, is the lack of confidence in state regulation. Most states are still in a fairly tight budget scenario. And I told you that you should remember that if it's not covered by U.S. federal law, it would be covered by state law. Some states are very green in the sense of their policies and procedures, green in that way. Other states, are frankly looking to develop, right? They want to bring jobs, and so their state law, there are groups that don't have a lot of confidence in saying, well, it's not covered by federal law, so I'm going to feel really good that the state of X is going to protect this water. A lot of people that feel it won't be protected. It'll go be sacrificed to sort of economic development. So that's the other, all of this, although we're fighting about what is a water of the U.S. in quotes, there's a whole lot of other stuff that we're actually fighting about in the process. So let's turn to another hot topic. I'm going to let you take this one because you did such a good job on it last year.
So here's a case where there's apparent tension between the Section 404 and Section 402 of the Clean Water Act. And the Supreme Court decided the case of Core Alaska, a mining company, versus Southeast Alaska Conservation Council, an environmental NGO, in 2009. Core Alaska proposed to discharge mining tailings from their gold mine into Lower Slate Lake, which is a lake in Tongass National Forest in Alaska. And they applied for and were granted a Section 404 permit from the Army Corps of Engineers because the material that they were discharging, mining tailings, was determined to raise the bottom elevation of Lower Slate Lake and was therefore classified as fill material under Section 404. So mining tailings have some solids and some liquids, so oftentimes a slurry. It's kind of hard to tell whether or not.
Kind of like concrete, a
Yeah.
little looser than
A
concrete.
little looser, yeah.
Yeah.
So sometimes it's it might come out of a pipe. It might be discharged by an excavator. Hard to tell whether it's fill material or a pollutant that should be regulated under Section 402. And the Southeast Alaska Conservation Council appealed the district court decision that said the 404 permit was okay. They appealed it because they said, well, EPA has promulgated technology-based effluent limitations for the ore mining and dressing industry, which apply to the gold mining industry. And there are limitations for various elements within the gold mining slurry, which SEAC said should be included in a 402 permit, not a 404 permit. Remember that EPA or a state authority issues 402 permits, and the Army Corps of Engineers issues 404 permits. 404 permits for dredge and fill material do not include effluent limitation guidelines in them. The 404 regulations talk about an alternatives analysis that must be undertaken to determine whether the fill is appropriate for discharge, and one needs to avoid adverse impacts or mitigate for the adverse impacts, and find that the discharge of the dredge or fill material is the least environmentally damaging practicable alternative, or LEDPA, under the 404B1 guidelines. So the Ninth Circuit said, yeah, that's right, where there are ELGs for a particular industry, like this gold mining industry, they should be in a 402 permit, not a 404 permit, but the Supreme Court reversed the Ninth Circuit and said that even though EPA had promulgated effluent limitation guidelines and new source performance standards for the ore mining and dressing industry, this particular discharge of slurry was fill, and it does not trump the Corps' 404 authority for permitting the discharge when it has the effect of fill. So the upper picture is Lower Slate Lake before the discharge, and the bottom picture is Lower Slate Lake after the discharge of the fill material.
So dramatic change there, but really, what that case is about is picking the right tool, and frankly, the more stringent tool, because a 402 permit is going to require compliance with water quality standards, technology-based effluent limitations, as Erin just said, whereas a 404 permit is basically an authorization to place the fill.
Right, but it's not just a willy-nilly authorization. It has one must go through those alternative analysis, but it doesn't have it's not backed up by effluent limitations. Those aren't included by the Army Corps. The statute doesn't say that they need to be.
Right. So we'll turn to another one that many of you have heard about, mountaintop mining or mountaintop removal, depending on which industry you're in, which perspective you take. You're either mining or removing something. And both are true, right? We are mining and we are removing something, entire mountains. So in this case, the mining companies, when they do their explosions to reveal the seams of coal, and they obviously create a lot of rubble, and this rubble ends up tumbling down and getting scooped up by trucks and so forth, and being deposited and essentially filling streams. Okay, you can think of how it would happen quite naturally. And so that would be the discharge of a pollutant. It's rock, okay, and it's going to be, to a navigable water, to a stream. So there's really no questions about those things.
It's going to change the bottom elevation of the stream, so it's filling it.
Right. So they apply to the Corps of Engineers for a 404 permit. And the Corps authorized 6 different fills, which I don't remember the statistic, but ultimately in this case I think would fill miles, quite like 300, it was a lot of miles of stream that would be gone. The stream would not be there. And there are restoration requirements afterwards and so forth. There are all sorts of things, but ultimately the streams would not be there any longer. And so this became, again, a sort of a conflict between EPA and the Corps in the sense that, one has one sort of mission in how it's looking at things, and the other agency has a different perspective. And in this case, EPA used its 404C authority to object to the Corps' issuance of the permit because of the unacceptable adverse effect on the resource. This was viewed as, just, an unbelievable open airing of dirty laundry between two government agencies. They're not on the same page? Well, frequently government agencies are not on the same page. And in fact, the mining company sued because, of course, if you're running a business, and these permits actually had been issued quite some time ago.
Right. The permits were issued in 2007, and it was 3 years later that EPA filed the final determination to withdraw its specification of allowing the filling of these particular streams.
And then in 2011 sort of changed its mind. So of course, if you're running a business, you're saying this is outrageous behavior by the government. How am I supposed to run my business when they could just pop up out of nowhere and suddenly tell me I can't do what I plan to do? I have shareholders that I'm accountable to, et cetera, et cetera. And so they sued, and they won, at least at the district court level.
So there may be an appeal.
There may be an appeal. But this is yet, another example of of the tension between, economy and environment. I think there is a tension there. I don't think, we say the two are compatible, and they can be compatible, and there might be ways to issue these permits in a way that wouldn't end up with the total destruction of the streams, and maybe those are the kinds of things we should be looking for, are more win-win solutions, but this one was not set up win-win. Here's another one that is hot. Sackett.
Yes.
You want to tee up
Yeah,
Sackett?
sure. I went to the oral argument. If you are ever in DC, if you're here just for the summer, the court's out of session as of today, but if you're ever back, anyone can go to hear a Supreme Court argument. If you get up early enough and stand in line, or if you're a member of the Supreme Court bar, you can go through the side door. But it's a really amazing way to see our democracy in action. So the Sackett oral argument was quite popular and took place in January. And involved what Alex referred to before as a tension over property rights and the environment. So the Sacketts, Mike and Chantal Sackett, are a couple. They bought a lot near Priest Lake in Idaho, and they wanted to build a home on their land.
And there were other homes in the area too, right?
Yeah.
So.
And the lot was separated from Priest Lake, I think, by another line of houses. So in the area, though, there had been wetlands before, and the Sacketts were told by EPA to stop excavating on their land, to stop filling the wetlands on their land, because they had not obtained a Clean Water Act Section 404 permit for filling their land. And the EPA also said, so you've not obtained this permit and you're in violation of the Clean Water Act. If you don't restore your land, if you don't remove the fill, you are under a compliance order to do that, and if you don't comply with the compliance order, you could face the threat of remember I talked about the $37,500 per day per violation until you come back into a compliance. So the Sacketts requested a hearing in federal court seeking a declaration that their property was not a wetland under waters of the U.S. It was only intermittently wet.
And there's other houses, and there's other,
Right.
they were very appealing case because they were stuck between the proverbial rock and the hard place,
Yeah.
right? If they follow the order and put the land back, okay, it's going to cost them a lot of money to do that.
Right.
And the issue is they don't think they have a wetland, but the government thinks they do.
Right, and now they have this compliance order that they want to challenge, and there was a question of whether or not the process in the Clean Water Act allowed for that pre-enforcement review of a compliance order.
Right. So the Supreme Court heard the case. I bet it was pretty dynamic argument. In fact, I used to have some quotes from the argument, but the question was finality. How final is this order telling them to restore the land? And the government attorneys, were also in a hard spot trying to say, well, there are lots of ways they could get around this or work it out. And Chief Justice Roberts said, I've never seen anything that looked more final before in my life. And if the government tells you to do something, people really don't have a whole lot of options. And so there was a pretty lively argument. Were there some other
Certainly.
interesting takeaway moments?
Well, I think it was Justice Alito who said, certainly, this could never happen in America, that you would get an order and not be able to challenge it. And so there was like Alex was saying, the argument about the finality of the order, the ability of someone with a compliance order to challenge that order.
Mm-hmm.
And the Supreme Court held that the Clean Water Act Administrative Compliance Order was a final agency action subject to Administrative Procedure Act review, that the Clean Water Act didn't preclude pre-enforcement review, and it didn't actually reach the merits of whether or not the Sackett's land was actually a water of the United States or not. So the ruling focused on the administrative law aspect of this.
And so the case was, the court could have gotten into, again, the wetlands issue, and a lot of people, the jurisdictional issue. Everyone thought that maybe they would go that far in Sackett, and there was a lot of speculation that they took that case to clarify the significant nexus issue and all this other stuff that we talked about. But really, they went to an issue of administrative law, which is, you get an order from the government, and if you have an issue with it, you should be able to raise that somewhere before you spend a whole lot of money. So I think we should breeze through the next couple ones, because there are so many current issues. But I'm just going to flag, because I put this one in here, the fact that you don't always see lawsuits, that are at the Supreme Court level that set major policy direction. You might also see a lot of settlements or consent decrees. And one of them that's very important would be the Chesapeake Bay decree. And I just highlight it because it's a settlement that governs 6 states in the District of Columbia. So it would be like a mega settlement. I guess the environmental equivalent of a class action. All of these states coming together, trying to figure out how to restore a major watershed. And in consent decrees, a lot of goals can be set. In this case, a total maximum daily load for nutrients for the bay was to be developed by 2010. It was. All the states within had to do different things. There were requirements for permittees, requirements for animal feeding operations. So I just highlight this to you all. And finally, we want to get the bay cleaned up by 2012. Well, again, we're not going to have the bay cleaned up by 2012. But it's important to note that there are lots of ways that we see all different stakeholders struggling with trying to make big change in water. And there have been a lot of critics of the Chesapeake Bay Decree and the slow progress, but I think also there are some good things coming out of this. You have 6 different states working together to try and restore a watershed. And you do have some new requirements coming along. Another area that's kind of lively is stormwater. And that also is, I'm not going to go into great detail here, except to say that every time it rains, you should think about all the pollution that's going down the drain and hitting waters that you may be later kayaking or fishing in. And we continue to try and figure out and define the scope of what is stormwater. How do we manage stormwater? Because stormwater is permitted. And so, for example, the District of Columbia holds permits for the stormwater outfalls into the Anacostia River. Well, if you work for the District of Columbia government, or as a friend of mine worked for the city of Los Angeles, they say, and he would often say, how do I control the behavior of 3 million residents of LA? And that's what stormwater really is. Stormwater is the result of our collective impact on water. And there are a lot of things that cities can do, like street sweeping and trash programs and green infrastructure, which you probably hear a lot about, putting soft surfaces out in the pervious area to soak up pollutants before they go. But stormwater is still an extremely vibrant area. So I don't know if there's much more to say about that, except we want to leave some time for questions. Another thing that I put a slide in on is we talked about TMDLs, and right now the agency is really focused on what will this program look like in 10 years. So that's kind of exciting and interesting, and there's a lot of focus on the reality that the law is not going to be changed dramatically. We don't think Congress is going to reauthorize the Clean Water Act in any major way anytime soon. And so trying to be creative with, basically, I sometimes say, you know, it's like driving a 1977 car, and you might like to trade it in and drive, you know, the 2012 or the 2013 model, but you can't. So how do you retrofit and, you know, and make that 77 car run and be as fuel efficient and as, you know, comfortable and as effective and safe and everything? And there are some parts of the Clean Water Act that, frankly, you know, not the whole thing, but there are pieces we might like to trade in and upgrade. But we probably can't right now. And so there's a lot of, I would say, policy work being done to try and figure out how to make this law more effective. And then I mentioned money, and so I've got my money handout for you here. Just know that money is going down. And in fact, you might remember the Budget Control Act, which kicks in January, which is if Congress doesn't figure out how to get a tighter budget in the next couple months, there will be automatic rescissions that hit in January. So it's not a pretty picture for funding. And the Supreme Court keeps us busy.
Yes, so keep your eyes open this Supreme Court term for 2 Clean Water Act cases. The first is commonly referred to as the Forest Roads case. And so this case will be about whether the citizen suit provision of the Clean Water Act, Section 505, can be used to challenge the validity of a rule and bypass judicial review of that rule, and also whether the Ninth Circuit erred in finding that stormwater from logging roads is industrial stormwater subject to the Clean Water Act, even though EPA has said and in practices that it's not industrial stormwater. In the other case, the court granted cert on one question in this case, and it's the water transfers question that Alex demonstrated before. When water flows from one portion of the water of the United States through a concrete channel and into another portion of the same water of the United States, is there a discharge from a point source, from an outfall? So the Supreme Court certainly remains interested in the Clean Water Act. So we'll be interested to see what happens there, and we're happy to answer any more of your questions that you might have this afternoon.
So we saved some time for questions, didn't we? And so hopefully those of you on the phone, remember you can email mmcmurrin@eli.org. Here you go.
Perfect.
Questions for the presenters can go there from the phone and from the room. Yes.
Can you talk about how TMDL implementation works for non-point sources?
Oh, yeah. Well, I'll take a first
Okay.
crack, and then Aaron can certainly chime in. So the question is, how does TMDL implementation affect non-point sources? So I talked to you about that pie. The pie will be divided up to point sources, and then there'll be a load allocation given to the non-point sources. They do get a load. They do get their share. How do we encourage those farmers, agricultural operations, construction, maybe non-regulated ranching? We encourage them to use best management practices on their property to reduce. However, we can't really make them do those things. We can fund them through 319, which was one of those funding programs. We can strongly encourage them. The U.S. Department of Agriculture has a number of programs that funds best management practices on farmland. So one of them might be to encourage the farmer not to farm or till the land all the way up to the edge of the stream, but actually to have a buffer. Well, to the farmer, that buffer's money, right? That's land that they're not actively growing something in. So you sort of have to make the case that it's the right thing to do. There are a lot of, I say farmers, but we're also talking about big ag, that are stewards, and want to sort of do the right thing. There are others that need to be strongly encouraged to do the right thing. Long story short, if the water body is still impaired and you're a point source permittee and your permit comes up, you can find your permit getting tightened because the water is still impaired. And so the reality is that the less action there is by that non-point source sector, the more difficult it can become for the point sources. And that's another big tension that exists, frankly, in real life, is how fair is it to keep asking the industry to do more when the real problem might be someone else. And we have a question. Okay. Why are the questions from the folks on the phone not being answered? I cannot hear questions. I think that was for you.
It is, but there's actually a question. Can there be a brief explanation?
I didn't see it. I'm so sorry.
Here's the question. The question is, can there be a brief explanation of the excluded agricultural stormwater discharges, for example, or give examples? Are all agricultural, are all ag sectors, I suppose, excluded from stormwater discharges?
Well, not all. Consolidated animal feeding operations were recently added and to the point source program, and it includes like the manure fields. So it's not just the pigs in the pen that we showed you, but also things that you might look at and it appears like open land, but it's viewed as part of the industrial operation. So to capture agriculture, you really have to call it sort of some sort of industrial activity, like logging roads, like the Supreme Court just granted cert on, okay? So to get them in, you've got to say this is like an industrial operation that we can kind of draw a boundary around.
Yeah, I think that's good.
Yeah. Sorry for misinterpreting the question.
Yes.
My question is about the distinction between fill material and a pollutant. And so, for example, in the Slate Lake case, that material was determined to be fill, but based on the definition of pollutant in the Act, it could also be read.
You've hit that exactly on the head, and that's what the Supreme Court really struggled with. So
So there's not necessarily a liquid-solid distinction. I mean, it mentions rock and sand.
Right. Well, there's a 2002 fill rule that was jointly promulgated by the U.S. Army Corps of Engineers and the EPA, and it harmonized the agency's previous interpretations of the definition of fill. Prior to 2002, there was a disconnect whether the fill is being discharged, whether the purpose of the fill was to just be discharged as a waste, or whether the purpose was to build quick land in the landfill. And the Army Corps looked at that, and EPA looked at the effects of the fill. Does the addition of this material raise the bottom elevation of the water? And as policy and regulations stand right now, that's what we look at. We look at the effect on the bottom elevation of the water, and then if it raises the bottom elevation, we call it fill. But you have absolutely hit the nail on the head. Is that cognitive dissonance about why does EPA have effluent limitations for a particular sector of discharges, and there might be toxics in there, there might be other pollutants that we don't want in there, but if the effect is to raise the bottom elevation, then it's fill. And so there could be a change in that policy, who knows, but the way that the policy stands right now based on the Core Alaska decision and memos of EPA's policy, EPA's memos, if it has the effect of fill, it's regulated as fill.
More questions? Yes. So, great question when we mentioned the variability of sort of water availability and even location of water due to climate change. Would there be any additions to the Clean Water Act to deal with climate change? Two thoughts I have on that. One, the US EPA Office of Water recently released a really excellent plan on climate adaptation from the Office of Water. It's a really fabulous, thoughtful plan, but it's a plan. It's not a law. It's not a regulation. It's a thought piece, a very well done and comprehensive thought piece. The other thing that we see is some pressure on the TMDLs. A total maximum daily load has to have a waste load allocation that goes to the industrial sources. The load allocation, which this gentleman asked about, which would go to the non-point sources. And then it has to have something called a margin of safety, which is how are we really sure that, we haven't over allocated, or over assumed. We want to make sure that we've comfortably fit within that pie plate and frankly, fill the pie and leave a little bit around the edge, the margin of safety. And there has been litigation up in the Lake Champlain area that a TMDL for Lake Champlain, that climate considerations should be part of that margin of safety. So I think what you're hitting on is that there's a great desire to see climate change considered in policy and water policy. How to do it, certainly not in the existing law. Is there anything clear? Will there be amendments? I don't think so.
Because it's clearly going to affect both water quality and quantity.
Mhm.
And so I would watch for developments and thoughts on whether water utilities are ready for shortages of water due to climate change, whether ambient water becomes so hot that it can no longer be used as cooling water for industrial processes, and can it still meet water quality standards, and how do we adjust dischargers? How does a permitting authority adjust dischargers, effluent limitations, knowing that the water that's going into their facility as cooling water is already not that cool, and it may come out even hotter.
There's also the Climate Ready Estuaries program that EPA has, which is estuaries are certainly very sensitive ecosystems, and certainly sensitive to temperature and flow. And so there's a Climate Ready Estuaries program, and there's also a Climate Ready Utilities program, which Erin just alluded to the fact that water and wastewater utilities need to be thinking about water availability and how they manage water. And in fact, the whole concept of wastewater is really changing, where we find that due to water availability, we find us really saying maybe it's not wastewater.
Maybe it can be recycled.
Maybe it could be recycled, maybe it could be reused, maybe it could be sprayed. It's not clean enough to drink, but is it clean enough to irrigate a soccer field? In LA, the people rejected that soundly by starting the Toilet to Tap campaign, which said, no, we don't want our kids playing soccer on a field that's been irrigated with gray water, even though it's pretty clean. You wouldn't drink it, but it's good to grow the grass. But people wonder, are there bacteria there? Is my child going to get sick? So again, a lot of public health, public policy issues come along with some of the reuse that is evolving. It's a huge area of growth, huge area of growth.
Yes. Well, the agencies, I believe that the goal that the agencies probably had was to clarify for the regulated community and for their own staff to figure out how to do jurisdictional determinations and determine whether or not there was a Clean Water Act jurisdictional water. The regulations, the statutory definition of navigable waters is very short. The regulatory definition is a little bit longer, but it doesn't get into, it just has that list of what is jurisdictional. Scientifically, hydrologically, there's a lot more to think about when one is looking for jurisdictional water. And so the guidance, which is available on the internet, offers field staff more of a roadmap to what do you look for, what tools can one use to determine the jurisdictional nature of a water. So a guidance doesn't have the force of law. It's not a regulation. It's not a notice and comment rulemaking. So it can only be just that, be guidance. But it's many guidances sort of illuminate nuances within regulations so that a field staff or a practitioner can have a better idea of where they're going.
Yeah.
That's what's inherently within the Act, its authority to issue guidance.
Well, the Act gives EPA and the Corps authority to promulgate regulations to administer the Clean Water Act and just in general to administer the Clean Water Act. And agencies, not just EPA, but lots of federal agencies offer guidances that further interpret their own regulations in case there are areas that are unclear to the public.
And one of the issues sometimes becomes and in this issue it's specific, should we be doing actually a regulation, like a really formal thing? The problem with regulations is they take a very long time. In this case, the guidance is also taking a long time because you don't really by doing a guidance, you don't really get rid of the inherent tensions in the issues. And so it used to be that guidance was viewed as a little bit more expeditious, and you could get, oh, people are confused. Let's get something out really quick to kind of clarify things. I think, frankly, now as I've watched it evolve over my time, the guidance process is now as bogged down almost as the rulemaking process. Is that guidances still go through the Office of Management and Budget? They still get all this review, and they've almost become like regulations in that a guidance can move as slowly as a regulation. And now sometimes people say, maybe we get a regulation done faster than a guidance would get done. This is one of those areas. It really depends on the controversial nature, I think, and the difficulty of the issues. And this is about as hard as it gets. I think we're close to time. So we're happy to stick around for a minute or two for any further questions, but I want to let Chandra do her closing remarks.
Yeah, just a few. So thank you everyone for joining. Just to let you know that the PowerPoints are up on the event website, and the recording will be as well, hopefully in a couple of days. Thank you very much to Alex and Aaron for an excellent session on Clean Water Act, and thank you all for joining. Thank you.
Feel free on your way out to maybe grab one of these budget charts just to give you a sense of what's going on with money.